Good afternoon, everyone, and thank you for joining us again for Bond's weekly webinar about a variety of topics that may be of interest to your business. This week, we have a great panel of speakers for you. But before we get to that, I wanted to just give another reminder that Bond will be hosting its workplace seminar coming up in May and June in various cities across the state. You see the dates here on your screen right now. You can head to our website to register for that. Always a really valuable day of programming. So as for today's agenda, this is what we have up. First, in the spirit of spring with Earth Day just a few days ago, we have Caroline Westover with some spring cleaning in the area of your I-9 compliance. Always important to stay on top of that issue. Staying with the labor theme, Carrie Langen from our Syracuse Labor Department will be talking about an interesting Supreme Court case. Arguments were just heard recently by the court on the issue of religious accommodations. Then staying with the spring theme, we also have Subha Viswanathan from our Syracuse Labor Department talking about something that many businesses are gearing up for right now, which is summer interns and perhaps summer volunteers. And he'll talk to you about the issues associated with that. And then, so not to keep this a completely labor-focused week, we wanted to have some variety. And so we have Amy Reinhardt from our Syracuse property department. I almost said leasing department, but from our property department, talking about some basics of leasing, which we thought would be interesting to our clients. So with that, let's get started. I'll turn it over right now to Caroline. Thank you.
Thanks, Kristen. Good afternoon, everybody. And while we're in the midst of the spring season, I'm sure many of you have already begun your spring cleaning rituals at home, sweeping out the garage, cleaning up the landscaping, washing the windows. Now's also a good time of year for employers to conduct their own version of spring cleaning in the workplace. And one of those spring cleaning items, quite frankly, that should be on the to-do list is I-9 compliance. So hopefully I'm not telling anybody anything new that's on this webinar today, but I-9 compliance requires all employers to verify the identity and employment authorization of the employees that they hire to work in the United States. So every employer should have an I-9 form for anybody who was hired after November 5th, 1986. So what are our proposed changes, developments, I-9 updates that employers should be aware of in 2023? The first really development actually took place in 2022, and that's that the Department of Homeland Security increased penalties and fines. So as many of you know, but hopefully you've never experienced, the federal government assesses fines and penalties for employers who aren't in compliance with I-9. And these increases can be significantly substantial to your business if you aren't paying attention. For example, DHS increased the fines for substantive and uncorrected technical errors. For example, the penalty range for a first offense went from $237 to the range was $237 to $2360. The new range that took place in late 2022 is now $252 to $2507. And so all of the penalty ranges for first step, second offense, third offense, they have been substantially increased. And they add up. The second issue is penalties have also increased for employers who are employing unauthorized individuals in the workforce. So that range is now $627 to $5,016. That's the new range. And it goes up from there, such that by the time you get to the third penalty for unauthorized employment of workers, your range can now be anywhere from about $7,500 to $25,000. And the Department of Homeland Security previously used what they call a percentage formula to calculate what these fines and penalties were. They've now moved away from that percentage formula, and instead they're using an error rate, such that if an employer has an error rate of 50% or more errors on its I-9s when you get audited, that's more likely than not that an employer is going to draw a penalty at the max range. And so in some instances, if you've got a lot of violations and you're an employer with a lot of employees, you could be looking at fines in the six figures. Those are the figures that you're going to see that are headlining the news. And the more fines and penalties the government can assess, it enables them to hire more people to do these I-9 investigations. So The takeaway here, not to scare anybody, but simply, much like everything else these days, everything is more expensive, including these fines and penalties from the government. So that's one update that has carried into 2023. The second is really a proposed change that many employers and HR professionals are talking about, and that's the new proposed Form I-9. We've been receiving a lot of questions. When's the new form coming out? What will it look like? And so we're going to take a moment or two here just to talk about what those proposed changes to this form are. The first version, so late in 2022, the government had a notice and comment period to say, here are the proposed changes. We want feedback from employers. And so what they've proposed for starters is shortening the form. Right now, it's a 2-page form. And they want to shorten that now to be a single-page form where sections 1 and 2 would be on a single page. And then section 3, which pertains to the re-verification, which really is only limited for rehires, name changes, or when somebody's work authorization expires, that would become a supplement. So to use as needed, but they really want to shorten the length of the form. The second change that has been proposed here, and I chuckle a little bit when I say this, is they want to shorten the instructions. Currently, the federal government instructions for this Form I-9 are 15 pages in length. They want to shorten that to 7 pages. From the clients that I've spoken to, nobody seems to mind how long the instructions are if they're actually helpful to the client. The instructions right now leave a lot of blanks such that clients, it's not clear on how to comply or complete the form in every instance. So shortening the instructions by half may be helpful for paperwork reduction purposes and in an environmentally friendly move. But I think at the end of the day, employers are just hoping that the instructions are succinct and clear. And then the last change that we're really seeing is more technical. So Department of Homeland Security currently advises or suggests to employers that when you have blank spaces on the form, that you put NA, not applicable, where it's not applicable. What they're proposing here is to remove really that administrative protocol without needing to put NA in every blank space. The short version is we don't know when the new Form I-9 is going to be released. We anticipate that it will be released in 2023, but a definitive date has not yet been given. So stay tuned for that development, and we'll certainly let all of you know once the new form's been released, and we'll go through it in detail with you. But for right now, employers should continue using the last or most recent version, which is the October 21, 2019 version. Even though it had an expiration date of last October, this is still valid for use right now because it was the one that was most currently released. Another update that we wanted to share here is the upcoming expiration date of COVID-19 flexibilities as it pertains to Forms I-9. So at the start of the COVID-19 pandemic back in March of 2020, the Department of Homeland Security recognized that it would be impossible for employers to physically look at the original documents that employees were turning in for I-9 purposes. That is the normal traditional practice. An employer representative should be looking at what an individual has submitted for this process. During COVID, that couldn't happen. So they implemented flexibilities, which, for example, have remained in effect to date over the last 3 years. But those flexibilities allow employers to conduct this I-9 process remotely. So instead of looking at things in person, employers had the flexibility of looking at documents by fax, by email, by FaceTime, video, by Zoom, for example. And that was a great benefit to facilitate this process for employers. What we saw during the pandemic, however, is that many employers misread the application of that rule because it did not apply to all employers. It was only designed to apply to employers whose workplace was temporarily shut down because of the pandemic. So, for example, if you were a college and university and you were closed, nobody expected HR or a new hire to come to campus purely for the I-9 process. So if you were closed, you could do this remote verification process. The other circumstance is when you had a new hire who was working remotely or who was unable to come to the office due to travel restrictions or COVID quarantines, etc. So those flexibilities have remained in place. When the individual is set to come back, or when your business has reopened, as most of ours have now, employers are obligated to complete the second step of that process, meaning that they still needed the individual to come back in and bring those original documents so that the employer representative could put eyes on them and take a look at them and update the I-9 form. So I think a good spring tip and a reminder here is, if you were an employer who used this COVID-19 I-9 flexibility, make sure now to go back through and make sure that you've actually gone and looked at the originals for those employees that you did this remote process for. You'll want to update those, because in the event of an audit, the I-9 auditor is going to be looking to make sure that you've closed the loop on that. I would mention here that this COVID-19 I-9 flexibility is set to expire and will end on July 31, 2023. Another proposed change, given the positive reception that remote I-9 verification gave to many employers, Department of Homeland Security is considering making or implementing a process that would make remote I-9 verification permanent. It's still very much proposed at this set time, but it's something that we're monitoring. The government may run a test or a pilot program to see how this works for remote I-9s. They may also implement certain restrictions or limitations on who can use remote verification. For example, if you've been found to have violated I-9 rules in an audit, you may not be permitted to use the remote process if and when they develop it. Or we anticipate that the government could also encourage employers to enroll in E-Verify is kind of a form of a carrot and a stick. You get to use remote I-9 if you enroll in E-Verify, just as an example. We're waiting to see what the final rules are on that and what protocols the government may implement, but that is on the horizon. And so we'll provide updates when we get details about that. And finally, I would just say, in terms of general I-9 issues, now's the time to spot check how your I-9 compliance is. So take time to make sure your I-9 house is in order. For example, who in your organization is responsible for the I-9s? Has that person been trained recently? Are they up to date on the newest rules? Given the penalties that we have here, it's very critical that you have somebody well-versed in this law to complete these forms. Are I-9s completed in a timely manner? I would also suggest, and have suggested to many of our clients, that they pick a random sampling and see that they're being completed timely, accurately. Do you have a system in place to remind you when certain employees' work authorization documents are being expired or will expire? And if you're storing your I-9s electronically, as many employers are doing in this day and age, is your electronic system compliant with the I-9 requirements? In closing here, I would just note that the calls that we often receive from clients on I-9s typically involve documents that people don't see every day. Many clients are versed with the driver's license and social security card. And that's usually what many people get 70, 80% of the time for I-9 purposes. But if they get a work authorization card, if they have an employee who has a sponsored work visa, those are areas where we see a lot of mistakes on the Form I-9, or people forget to go back and re-verify somebody. So I would encourage you, we know that different work rules can be tricky here and visas. So if you have questions about an I-9 that's unusual to you, best to take the 2 minutes to call your immigration attorney or your labor and employment attorney, get that verified, get that checked to make sure you're on solid footing moving forward. We'd always rather speak to clients for 2 minutes than have to work them through or counsel them in an audit later on that could result in a lot of hefty fines and penalties. So with that, I will turn it back over to Kristen.
Thanks, Caroline. That was really helpful, very practical, and in fact, very popular topic, it looks like, because the Q&A is very lively right now. So if you want to take a look at those, I know one recent question is, what do you do if during your audit you find there are employees that don't have an I-9? Is that something you can quickly answer for us?
Sure. So typically most employers will get a notice in advance of somebody coming on site to look at their I-9s, or if you have to turn over the I-9s. If you see that, you will want to have them get an I-9 and get it completed. What I will tell you practically, though, much better to do your self audit and get those issues corrected when it's voluntary, rather than the day before, the day after you get a notice of inspection from Department of Homeland Security. So again, one of the reasons why we're really emphasizing here, take the steps that you need to now to make sure things are in order. But again, if you get that I-9 audit, and you'll want to get that completed, but the auditor is going to know that it wasn't done timely, and they're going to know that you only did it on the heels of an audit notice. The I-9 audit process will allow for some corrections or paperwork corrections in certain circumstances, but if you're missing a lot of I-9s for people, they will take that into account with how many you're missing. And does that indicate that you just didn't comply at all? Or is this a one-off and mistakes happen? We can certainly understand that. So I think we just want to be careful.
Thank you so much. It seems like, based on the questions here, that an I-9 audit could be a full program itself. So if, perhaps Caroline, if you could take a look at those questions, that would, I'm sure clients would appreciate
Sure.
it. Now I'm going to turn things over next to Carrie Langan, who's going to talk to us about a pending Supreme Court case. Go right ahead, Carrie. Thank you.
Okay, thanks, Kristen. So as Kristen noted earlier, last Tuesday on April 18th, the Supreme Court heard oral arguments on an interesting case that's pending before the court that we just wanted to spend a few minutes to talk to you about today to get it on your radar. So the case name is Groff versus DeJoy. DeJoy is the Postmaster General. Groff was a postal carrier for the U.S. Postal Service, and his religious beliefs dictated that Sunday was a day of worship. So he informed the Postal Service that he could not work on Sundays. So the facts are a bit nuanced as to what actually transpired over the years that he worked for the Postal Service and whether he was required to work Sundays initially and the accommodations made. But what ultimately led to the case is that the Postal Service decided not to allow Groff to be exempt from Sunday work, claiming it was an undue hardship. At a certain point, the Postal Service contracted with Amazon, and Sunday work was really an essential function of the postal carrier. So instead, the Postal Service offered to help Groff find a different accommodation, and what they came up with was to get other employees to voluntarily swap shifts with him. So not surprisingly, as many of you may realize, there were problems with that. And there were a lot of occasions where coworkers would not agree to swap shifts, excuse me. So on those occasions, Groff just didn't come into work, and he was issued discipline for not coming into work on Sundays. So he ultimately resigned, and he sues the Postal Service, and it's a religious discrimination claim. Essentially, he said that the Postal Service violated Title VII by failing to reasonably accommodate him with respect to needing the day off for his religion. The lower court found for the Postal Service and said that, the accommodation that Groff sought would cause an undue hardship on the Postal Service. And the U.S. Court of Appeals for the Third Circuit actually agreed with the lower court and said the same thing. So now the case is pending at the Supreme Court. And again, there are a lot of nuances to the case, we only have a few minutes here. So I wanted to highlight what I see as the most significant issue before the court. And it's, what does undue hardship mean under Title VII? So by way of background, Title VII requires religious accommodations absent undue hardship on the conduct of the employer's business. But the statute, Title VII, doesn't define what undue hardship means. And it's been left open for the courts to determine, what the definition is. So courts have looked to a Supreme Court case in the 70s. I think it was 1977, TWA, Trans World Airlines versus Hardison. And in that case, the court stated essentially that requiring an employer to bear more than a de minimis cost to give an employee a religious accommodation is an undue hardship. And so again, this is a different standard than, for example, under the ADA, which many of you know is undue hardship is defined as a significant difficulty or expense. So here, for religious purposes, it's more than a de minimis cost. And since the Hardison case in the 70s, courts have debated whether the standard should be heightened, similar to the standard under the ADA. So Groff is obviously arguing before the Supreme Court that it should adopt the ADA's definition of undue hardship, the significant difficulty or expense test, rather than the de minimis standard that the Third Circuit relied on to dismiss his case. And it is a very interesting debate. There's actually a transcript, if anybody's interested, of the oral arguments last Tuesday on the Supreme Court website. So you can, go ahead and listen to it. Not really sure which way the Supreme Court is going to go with this. The decision is expected out in June. Obviously it would be reversing its own precedent. So, it's kind of open to, some debate as to what's going to happen here. The Supreme Court has taken an interest in religious liberties, so we really just don't know. And while requests for religious accommodations, they're certainly not as widespread as requests for disability-related accommodations under the ADA, as many of you know, and I've probably worked with on those issues over the years. We think, employers should keep a close eye on this, because to the extent that the court decides to define undue hardship as a significant difficulty or expense, I think you can expect to receive a lot more, a significant increase in religious accommodation requests. And it's also going to make it more difficult for you to deny the request claiming an undue hardship. So that's really the gist of kind of what's going on. And we wanted to bring it to your attention, and we'll certainly follow up once we receive the Supreme Court decision.
Thank you, Carrie. Thanks, Carrie. We certainly, as she mentioned, when we get a decision from the Supreme Court, you'll be hearing back from us about that. I anticipate we'll have an article about that on our website, and we'll provide an update during this webinar, because anytime the Supreme Court changes the standard in that way, it's big news in our world of labor and employment law. Okay, so up next, staying in the labor world, we have Suba again, who's a regular contributor to this webinar and has been providing us a series of presentations regarding wage and hour topics. And as I mentioned earlier, because it's internship season, we are going to talk today about interns. Thanks, Suba.
Thanks, Kristen. So yeah, with the college academic year coming to a close, a lot of college students are going to be looking for internship opportunities. We thought this would be a good time to sort of review the state and federal guidelines regarding when you can have unpaid interns and unpaid volunteers, as opposed to interns that you actually have to pay. Next slide, please. Just to kind of illustrate how these issues can arise and what the potential liability can be, I want to talk about this Second Circuit Court of Appeals case from 2016. It was brought as a class action. The plaintiffs were unpaid interns, either on the film Black Swan or at Fox Searchlight Pictures corporate office in New York City. And if any of you want to look up the case on the internet, you'll see that the duties that these plaintiffs were performing were not of extremely high educational value. One plaintiff who worked in the corporate office did things like photocopying contracts, filing, those sorts of kind of clerical tasks. One particular plaintiff who interned in the production department on the Black Swan film ran menial errands for the director. At one point, he was asked to go buy a hypoallergenic pillow for the director. So those are the kinds of tasks that these interns were assigned. Not of extremely high educational value, and things that you would ordinarily expect an employee to do, as opposed to an unpaid intern. So as you might expect, the plaintiffs alleged that they should have been paid as employees under the Fair Labor Standards Act and New York labor law and filed a claim in district court. The district court found in favor of the plaintiffs without a trial. The plaintiffs moved for summary judgment after discovery, and the lower court found, based on the standards that it was using at the time, that the plaintiffs should have been considered paid employees, and determined that that Fox was liable for back pay, liquidated damages, interest, and penalties. Fox appealed it to the Second Circuit Court of Appeals. The Second Circuit didn't actually address the merits of the claim. They didn't actually say one way or the other whether the district court was correct in the conclusion that it reached. But what it did say was that the district court used an incorrect legal standard. They were using the legal standard that the United States Department of Labor had issued at the time. And the Second Circuit said that we don't think that's the correct legal standard. So the Second Circuit created a new legal standard and then remanded it back to the lower court for an analysis of whether the interns should have been paid under the new legal standard. I'm assuming that the case was settled after this legal standard was created and it was sent back to the lower court, because there are no subsequent lower court decisions after the Second Circuit decision. Next slide, please, Kathy. So here's the new test that the Second Circuit created. They created what's called a primary beneficiary test, which is who's the primary beneficiary of the relationship? Is it the intern or is it the employer? And they created 7 factors to look at. And all 7 factors don't have to be met one way or the other. It's basically just looking at all of the factors together and determining, based on those factors, who does the court believe that is the primary beneficiary of the relationship. The first factor is the extent to which the intern and employer understand that there's no expectation of compensation. The second one is the extent to which the internship provides training that will be similar to which would be given in an educational environment. The third one is the extent to which the internship is tied to the intern's formal education program by integrated coursework or the receipt of academic credit. The greater the tie between the employer and the educational institution, the more solid ground you're going to be on to have an unpaid internship. So, if it's part of a course of study to do an internship in that student's field, and the educational institution has contracted with or created relationships with various businesses in the area to give its students those educational internship opportunities, and actually gives academic credit or treats it as being part of the regular program, then you're going to be on much more solid ground to classify that person as an unpaid intern. The fourth one is the extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar. Next slide, please, Kathy. The extent to which the internship's duration is limited to the period in which the internship provides the intern with beneficial learning. The next one is the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. Sometimes employers can get in trouble by having unpaid interns doing the exact same type of work that they pay employees to do. In those types of circumstances, you're almost certainly guaranteed to have the Department of Labor or a court say, that's really employment-related work, not educational benefit to the intern. The last of the 7 factors is the extent to which the intern and the employer understand that the internship is conducted without entitlement to a paid job at the conclusion of the internship. In other words, you can't use an unpaid internship as sort of a trial period to determine whether somebody might be a good employee. So you can't, say, hey, you know what, if you complete this internship satisfactorily and you do a really good job during your internship, then you'll have a job here. Next slide, please, Kathy. So the US DOL in January 2018 took these 7 factors that the Second Circuit created and revised its fact sheet on unpaid internships. So there's a link here to US DOL fact sheet 71. So you can just take a look at this link. It lists the 7 factors. Again, it specifically states all 7 factors need not be met one way or the other. The issue is just who's the primary beneficiary of the relationship. Next slide, please, Kathy. So as all of you know, as with most things, labor and employment, New York State likes to create higher standards for employers in New York State than under federal law. And this area is no exception. New York State has a fact sheet also. Again, the link is here if you want to take a look at it. It's a much higher standard than under federal law to classify individuals as unpaid interns. There's 11 factors instead of 7. And instead of the DOL saying we're going to look at all 11 factors together and kind of see which way this relationship weighs one way or the other, the DOL specifically says in the fact sheet, all 11 factors have to be met in order to classify somebody as an unpaid intern. Next slide, please, Kathy. So you'll be able to see in the fact sheet that, you know, a lot of these are kind of parallel to what the US DOL guidance is in this area, but there's some that's new. So for instance, this 4th bullet here says that the activities of the intern do not provide an immediate advantage to the employer, and on occasion, operations may actually be impeded. So under federal law, there's nothing that says that the intern can't do some work that benefits the employer as long as the primary beneficiary of the relationship is still the intern. New York State says the employer can't derive an immediate advantage based on the work of the intern. And on occasion, operations actually may be impeded. In other words, it's an inconvenience almost to the employer to have the unpaid intern there because the employer is so busy trying to provide these educational and training opportunities to the intern that its operations are actually somewhat impeded by it. The last bullet on this page, so it's basically the 6th bullet on the 11 factor list, says that the intern is notified in writing that he or she will not receive any wages and is not considered an employee for minimum wage purposes. Again, this is not a requirement under federal law, but it is under state law. So if you have a business in New York State and you're contemplating having an unpaid internship, you should put together a letter to the intern stating specifically that this is an unpaid internship, you're not going to receive any wages, and you're not considered an employee. Next slide, please, Kathy. So here are the last 5 factors. You know, again, a lot of these are different from under federal law. So the 3rd bullet on this page says the training the intern receives is general and qualifies the intern to work in any similar business. So if what the internship is in your particular business is teaching the intern how to do specific processes and activities that are very specific to your business, it's likely not going to meet this factor under the New York State 11 factor test. The screening process has to be different. You can't use the same type of employment application that you would use for employees. You can't go through the same sort of interview process that you would, that you do for your employees. If you advertise for an internship, it has to clearly state that this is educational and it's not an employment related position. Next slide, please, Kathy. You know, sometimes employers will say, well, what if I don't solicit this? You know, what if this is, you know, my friend saying he's got a son who's coming back from college, just finishing his 3rd year of college. You know, can my son kind of, you know, come work for you? He doesn't need to be paid. can he just come work for you just to get some experience? He hasn't been able to find a job. I just want him to get some experience kind of doing what you do because he's interested in your field. There's no such thing. There's no such thing as unpaid volunteers in a for-profit business. So regardless of whether you solicit a person to come work for you as an unpaid intern, or that person volunteers to work for you on an unpaid basis, you simply can't do it unless you meet the unpaid internship requirements under state and federal law. There's no such thing as unpaid volunteers in a for-profit business, but there is in the not-for-profit sector. So not-for-profit organizations can have unpaid volunteers. And again, there's a link to a fact sheet put out by the US Department of Labor that you can take a look at. There's some caveats to that general principle. So even though somebody can volunteer in activities that are genuinely charitable, educational, religious, those sorts of activities, you can't have volunteers in commercial activities that are run by a not-for-profit organization. So if you're a not-for-profit, museum, kids museum, for instance, and you have a gift shop, you can't have a volunteer working in your gift shop. It's got to be something that is kind of advances the actual purpose of your not-for-profit organization, the charitable purpose, educational purpose, or religious purpose. There has to be no expectation of compensation. An unpaid volunteer cannot perform work that's ordinarily performed by paid employees. And finally, you can have employees of your organization volunteer, but you can't have them do the same type of work that they do as employees. So for instance, you can have an employee of your not-for-profit organization, if they're ordinarily employed in your accounting department, for instance, but they want to volunteer to work a table at a charitable event that you're holding. That's perfectly fine because it's a completely different kind of volunteer position than what they do as an employee. But you can't have the person do the same work as a volunteer that they're being paid to do as an employee. Next slide, please, Kathy. So just some general considerations before I close. Just begin with the assumption that everyone who performs work for your business should be classified as an employee. It should be the exception rather than the norm to have an unpaid intern or a volunteer, or a volunteer in the not-for-profit sector. Written contracts or offer letters can be helpful, but it's not going to be determinative. So the USDOL isn't going to say, great, you have a contract where the person agreed that they're an unpaid intern or agreed that they're simply a volunteer in a not-for-profit organization. That's not going to be determinative of the issue of whether they actually meet the standard to qualify as an unpaid intern. Fair Labor Standards Act, minimum wage requirements, and New York labor law minimum wage requirements can't be waived by the employee in a contract. The fact that the intern requested to work at your business without being paid won't shield you from liability. And just a reminder, you should consult with legal counsel before you allow anyone to work at your business on an unpaid basis. If any of you have any questions, feel free to contact me separately from this webinar or put a question in the Q&A and I'll try to get back to you. Thanks, Kristen.
Great, thanks, Suba. We're going to move on to our final topic for today from our property attorney here in the Syracuse office, Amy Reinhardt. So go right ahead, Amy, thank you.
Thanks, Kristen. And thank you to all of you for listening to the webinar today. Thank you for giving me the opportunity to share with you some leasing provisions that we think might be helpful to be aware of, or in a current lease you might have, or aware of if you're negotiating a new lease. So we just want to point some of those provisions out to you today, talk about some pitfalls. This is a little bit different approach than probably what you're used to hearing on the webinar, but given that we're we practice property law, there really aren't a ton of changes that we see on a regular basis, like you see in labor law, in the litigation world. And so we did have a major overhaul in the landlord-tenant laws in 2019. In 2008, there was a significant change to the adverse possession laws in New York State. But we once in a while we get an interesting case that shows up that it requires our attention to in how we practice law on a daily basis in the property world, but it's not as quickly is moving and is evolving as some of the other areas of practice that you might see. So we thought we'd take a different approach today for our segment and talk about some things to be aware of in your leases. If you are a tenant, if you are a landlord, basically everything I'm going to say, you're going to want to do the opposite if you're the landlord position. So today we're going to just talk about things from the tenant perspective. But again, if you just flip flop it for the landlord, that's all you need to do. If you're not a landlord or a tenant, I'm hopeful that some of this information will be helpful to you in the future at some point. So yeah, with that, so I just want to, we in the property department here practice general property law. So we do a lot of buying properties, selling properties, leasing on behalf of the landlords and tenants, lending work, pretty much your full scale property work, anything you can think of related to property matters. When we negotiate a lease on behalf of a landlord or a tenant, if we've done our job correctly, everything goes smoothly once the landlord and tenant are well on their way. But some things do come up, and we get questions from clients all the time about what do I do if I need to stay beyond the end of the term of my lease? Or what do I do if I need to terminate my lease early, or I need to get out of my lease? And we hear that one sometimes. Sometimes parties don't get along. The landlord isn't doing what the landlord's supposed to, or the tenant's not doing what the tenant is supposed to. So what do we do? What do we do in those instances? So my goal today is just to point out a few provisions in the lease of where to look to find answers to some of these questions. Or again, if you're negotiating a new lease, some kind of tips for certain provisions to look for. Some of these provisions get overlooked or lost in the legalese of the lease. So I just want to point them out to you. The first question we often get is, or one question we often get is, I'm going to be entering into a new space. Kathy, you can go to the next slide if you don't mind. I'm going to enter into a new space. My space isn't going to be ready when my lease expires. So then what do I do? What happens when I need to stay beyond the expiration of the term of my lease? Well, you're going to look for what's called the holdover provision. And that provision in the lease is exactly what it says. It's what happens if I hold over beyond the expiration of my term. Usually these provisions address the type of tenancy that is created following the expiration of your lease. Is it a month-to-month tenancy? Is it a tenancy at sufferance? That has implications for termination of the lease by either party. We won't get into all that today, but it's just, I just want to point out to you that that's something that's addressed in a holdover provision. If you're negotiating a new lease, you're going to want to either make sure that you have the lowest rental amount possible in that holdover provision, or not address rent at all. Because what happens if there is no holdover provision, or if rent is not addressed in the holdover provision, the current rent that you're paying under your lease remains the same. If you're negotiating a new lease, you want to look at whether or not there's going to be any liability if you hold over beyond the expiration of your term. If you have a current lease and you're trying to decide what are the expenses if I hold over beyond the expiration of my term, is there going to be liability to the landlord if I don't leave? So if the landlord claims that the landlord cannot get another tenant because I'm there longer than I should be, am I going to be liable for those extra liquidated damages or the difference between my rent and fair market value? It could be a whole host of things. So if you're negotiating a new lease, you want to eliminate any liability for holding over. If you have a current lease, it's good to look and see if you're going to be liable for any possible damages. And again, you want to make sure that that holdover rent that's addressed in that provision is either as low as possible, and that it only applies to your base rent, not any additional rent. Generally speaking, with some limited exceptions, if there is no holdover provision in your lease in New York State, the default is that you're a tenant from month to month, and the same tenant terms and conditions of the lease will apply unless and until notice to terminate is given by either party. So if your lease doesn't address it at all, you're good on a month-to-month basis until either party terminates, as long as the landlord is accepting the rent that you're paying. So those are just some key things to think about if you need to stay a little bit later when your lease is going to expire. The next provision I want to talk about is force majeure provision. This provision is one of the provisions that was discussed a lot during the COVID period, mainly because tenants were wondering, if I can't operate, do I have a right to withhold rent? And that those provisions are probably still being litigated at this point. And we could probably do a whole segment on that. But my goal today is just to point out to you that there often is a provision, there are often in most leases, that addresses excuses and delays in performance by the landlord and or the tenant. If you have a current lease and there's some reason that you're not able to perform, either it's a repair obligation and you can't get supplies, maybe it is because the government is telling you can't operate. You're going to want to look for that force majeure provision and see what it addresses. If you are negotiating a new lease, you want to make sure that that provision is as broad as possible if you're the tenant. You want to make sure it includes as many instances that are covered by giving you an excuse for delay in performance that you can. So in most force majeure provisions, there's a list of what qualifies as a force majeure event. And if those events occur, you may have an excuse for the delay in performance under the lease. The other thing you want to make sure is that it's mutual. We see leases come in all the time that the force majeure provision only benefits the landlord. You want to make sure it's going to benefit both the tenant and the landlord, or just the tenant. Obviously, depending on who we represent, we just want to make sure that you're covered and you're protected by that provision if and when you need to engage it. So that's a force majeure provision. The next provision I want to talk about is something that gets overlooked quite a bit. It's basically just an operating covenant. A lot of leases will have something in the lease that requires you to operate for the entire term of the tenancy. And if you don't, you could be considered in default of the lease. So the first question is that you need to, if you're in a situation where you may need to go dark for a while, if you have to complete some renovations, if you're thinking you need to terminate early, something to that effect, you want to make sure that there is no abandonment or going dark provision in the lease. If there is an operating covenant, you want to make sure that whatever you need to do is completed during that time before a default is triggered under that provision. If you're negotiating a new lease, you want to try and make sure there is no operating covenant, but the landlord may require one for various reasons. The last thing you want to make sure you do if you are negotiating a new lease is allow for a carve out if you are going to complete renovations. A lot of times we just make sure that renovations would not trigger any sort of going dark provision or a violation of an operating covenant. So the only reason I mention this provision is because a lot of people don't realize that it's there, and you don't want to all of a sudden be in default of the lease and not realize it. So this could be a standalone covenant, or it could be part of a default section in the lease. The last provision I want to talk about is in the case of default. So we get a lot of questions about if we need to go to a new space, if we need to find a new space and we have 3 years left on our lease, what are we supposed to do? Excuse me. So the first thing that we typically do as the tenant's attorney here is look at the default provision to help the client raise pros and cons about terminating their lease early. For example, if you have 3 years left on your lease and the monetary damages are going to be significant, then that's going to obviously go in the con category. One particular provision, and I'll try and wrap this up because I know we're running short on time, but one particular provision that we look at is whether or not there's an acceleration provision in the default section of the lease. That allows the landlord to call all rent due from the date of termination or default until the end of the lease all at one time, basically like a due on sale clause in a mortgage. Negotiating on behalf of the tenant, we obviously try and make sure there is no acceleration provision and require the landlord to collect month rently from the date of termination or, default until the expiration of the term. That requires the landlord to either sue the tenant monthly, to sue the tenant monthly, or wait several months and then sue it once for the past due rent for several months preceding that date. Basically, what it encourages the landlord to do is go find another tenant. And then upon finding another tenant, the cost of litigation and the burden of coming back to the tenant to try and collect on that past due rent is significant. And it's easier for the landlord at that point to just kind of move on, and not the tenant may get out of paying the full amount of rent from the default date until the expiration of the term. So there's just a few provisions of leases that we wanted just to point out, to be aware of, to take note of. If you have current leases, be aware that some of these provisions could be in your lease. If you're at a crossroads in your lease tenancy, or if you're a landlord, just some provisions to be able to look out for in the future. Back to you, Kristen.
Thank you so much, Amy. And this is why I'm glad I work for a full service law firm, where if a client does have a question about a leasing situation, I can just pick up the phone and call Amy, because I haven't heard about a number of those terms since law school. So I really appreciate it. So that wraps things up for today. I know we ran a few minutes late, and sorry about that, but it was a lot of good content today. Here is the contact information for our presenters. If you have any follow-up questions, they are certainly happy to talk with you about those. And I want to just mention one more thing. Don't have this on a slide. This may have been mentioned at last week's webinar, but we are having a special webinar this Thursday at 8:30 a.m. to cover the new sexual harassment model policy from New York State. So if you're interested in that, I'll be presenting together with Teresa Rusnak. That's this Thursday morning. You can get the link from our website. So thanks for listening. Thanks for being patient with us as we ran over, and we look forward to talking to you in future weeks. Take care.